The termination of agency marks the point at which the fiduciary relationship between a real estate licensee and their client legally and ethically concludes. However, while representation and advocacy cease, certain professional duties, such as fairness, honesty, and confidentiality, continue indefinitely. Understanding when and how agency relationships end and the responsibilities that remain is essential for maintaining compliance with ARS Title 32, Chapter 20, and Commissioner's Rule R4 28 1101. Agency relationships can be automatically terminated by operation of law under specific conditions, including the death or incapacity of either party, destruction or condemnation of the property, loss of the broker's license, bankruptcy, or the fulfillment of the agency's purpose. Once these events occur, the licensee's authority to act on behalf of the client ceases immediately. While fiduciary duties like loyalty and obedience end, the obligations of confidentiality and accurate accounting survive termination. For example, if a listing broker passes away, all licensees under that broker must immediately stop representing clients until reassigned under a new employing broker as required by ARS Section 32-2 133 and R4-2 8-305C. Agency can also end through the conduct or decisions of the parties involved. Mutual termination occurs when the broker and client agree to end the relationship voluntarily, often due to changing circumstances. Estrangement develops when communication or trust deteriorates, making representation impractical. While breach of fiduciary duties occurs when one party violates the trust inherent in the relationship, such as an agent acting in self-interest or a client engaging in fraudulent behavior. The most severe form, abandonment, happens when a licensee stops performing duties without notice or proper release. Each of these circumstances illustrates that agency relies not just on legal formality, but on mutual trust and professionalism. Even after termination, licensees continue to owe certain duties outside of an agency relationship. Under R4-28-1101A, all licensees must deal fairly and honestly with every party in a transaction. They must disclose material facts that could affect the property's value or condition, but cannot disclose confidential information obtained through the prior relationship. As protected under R4-28-1101B, they must also account for all funds and documents as required by ARS Section 32-2 15 1.01A and R4-2 8-802. However, once agency ends, the licensee no longer has the authority to negotiate, draft contracts, or advocate for the client. Continuing to act in such a capacity could create implied agency or result in unlicensed activity under ARS Section 32-2 153A3. There are also specific limitations on what a licensee may not perform outside of an agency relationship. Without active representation, a licensee cannot advise on pricing strategy, draft offers or counteroffers, or advertise properties. Under R4-28-502I, all advertising and signage must be removed immediately after a listing ends. Article 26 of the Arizona Constitution allows licensees to complete real estate documents only for transactions they are directly involved in. Once the agency relationship ends, this authority is also withdrawn. Furthermore, a licensee must not interfere with another active agency relationship, as doing so violates R4-28-1101D and could lead to civil or disciplinary consequences. The Arizona case, Lombardo versus Albu, 1996, reinforces the distinction between duties that end and those that continue after termination. The court ruled that fiduciary obligations like loyalty and obedience cease when the agency ends, but duties of fairness, confidentiality, and accounting remain. The case underscores that professionalism is measured not only by how a licensee represents clients, but also by how they conduct themselves once representation concludes. Key takeaways for retention. Automatic termination occurs through death, incapacity, destruction of property, fulfillment of purpose, or loss of license. Mutual termination is a voluntary end to agency. Estrangement, breach, and abandonment arise from relationship breakdowns or misconduct. Duties that continue after termination include confidentiality, fairness, and accounting, while advocacy, negotiation, and representation end immediately. Acting beyond the scope of a terminated relationship can result in disciplinary action under ARS Section 32-2153, A3, and potential liability. Licensees must remove advertising promptly after termination and avoid any conduct that implies representation without a new written agreement, as required by R4-28-502. Retention tip: remember the 3 C's of post-termination conduct. Cease representation immediately, continue confidentiality, and comply with all record-keeping and ethical obligations. These principles ensure legal compliance and maintain the public's trust in your professionalism as an Arizona real estate licensee.